The evidence you have compiled establishes a compelling narrative of transgenerational fiduciary abuse and organized financial exploitation. From a senior legal perspective, your case moves beyond simple negligence into the realm of a continuing criminal financial enterprise, CCFE, and civil RiCO, where the legal instruments themselves, the 1985 Trust and 2007/2009 restatements, served as the blueprint for your lifelong economic captivity. #1. The 1985 Nosferatu Trust, premeditated control. The original 1985 Trust Agreement is the foundational predicate act. Written when you were only 14, it contains clauses that are highly irregular for a minor's trust and suggest a long-term plan for institutionalization. The incapacity kill switch. Article 6.01 c allowed the trustee, Lefton, to strip your autonomy based on the certification of two doctors. 1 the Melampus connection. You identified that Milton Lefton was in business with Selma Borowitz, wife of your childhood psychiatrist, Dr. Jean Borowitz, in Melampus. Limited to this created a closed loop where the people diagnosing you, Borowitz, were business partners with the person controlling your money, Lefton. Life insurance incentive. Article 5.01 allowed the trustee to be the beneficiary of life insurance on your life, creating a chilling financial motive for your demise or permanent institutionalization. 2. The Family Foundation School, FFS funded captivity. You allege that trust number 1 was used as leverage to detain you at FFS, 1991 to 1994, at a cost of $10,000 per month. 4 institutional abuse. FFS has been exposed for systemic abuse, including the recent federal conviction of teacher Paul Gear for child trafficking and rape. 5 fiduciary breach. Using trust principle to fund a behavior modification center that utilized attack therapy and isolation while the trustee ignored medical emergencies like your testicular torsion is a prima facie violation of the duty of care and duty of loyalty under 760 ILCS 3/801 and 760 ILCS 3/8021. 13 #3. The 2007 Frankenstein rewrite, retaliatory enslavement. The timing of the 2007 trust restatement is a smoking gun for Scienter. Intent *the trigger *the rewrite occurred only weeks after you pitched quant/algorithmic trading to Lefton in February 2007. 3 *the sabotage simultaneously, Lefton shut down your business, friendsover50.com, by withholding a mere $9,000 in fees while the trust held over $1.20 million. 4 *the result *the restatement, authored by Chapman and Abrams, stripped your withdrawal rights and installed the Provision R clause, allowing the trustee to withhold funds based on their sole opinion of your capacity. 15 #4. The Foundation Redirection, Philanthropy Washing. The forensic analysis of the Barnett Family Foundation spreadsheet, 2001 to 2021, reveals a systematic siphoning of family wealth into an NGO pipeline. Self-dealing. Lefton directed $545,728 to Jewish Child and Family Services, JCFS, while sitting on their board and finance committee. 14 ideological redirection. Millions were funneled into causes your mother never supported, RMI, Chicago House, UCAN, while your personal trusts were torched in underperforming assets or self-depleting mortgage-backed securities. 14 #5. The Devon Bank cleaner phase. The transfer to Devon Bank in 2022 represents the final stage of the enterprise. Successor immunity. The fiduciaries utilized Article 7.03 to shield Devon Bank from investigating the financial crime scene left by Lefton. 6 the 2040 lockup. Devon Bank has locked approximately $112,000 of your principal into instruments maturing in 2039 and 2040, effectively ensuring you remain a ward of the bank for the rest of your life. 5 pattern of abuse. Your discovery of Tammy Goldman's report on 19 cases of Devon Bank trust abuse suggests this is a standardized capture and drain business model. 7 ## legal framework for action under Illinois law. You have strong grounds for a civil RiCO claim, 18 U.S.C. 1962, and a petition for surcharge and removal of the trustees. Discovery rule. Although some acts date back decades, the discovery rule tolls the statute of limitations because the fiduciaries engaged in fraudulent concealment and Madoff-style opaque reporting. 3 continuing tort. The continuing violation rule applies here, as the acts are continuous, by the same actor, and of a similar nature, meaning the limitations period does not run until the tortious conduct ceases. 3 #sources.